for somebody who might need Medicaid access at some point in the near future. So we're not saying that you must pay your child for care. That's always the best option for care. But if somebody would like to pay their child for care, there are ways to do that. But there are also, unfortunately, a lot of ways that people try to go about doing that in ways that will actually create issues for them instead. Whether that's tax issues potentially, on the kids' side of things, or potentially just divestment Medicaid issues if they're the ones making those transfers to that child. But before we go into a lot of information on that, just a couple quick items. You can submit questions to us and we'll see them pop up. And then keep an eye out for emails coming to the email that you used to sign up at the end of this, where we'll send out a feedback form, which also gives you a place to let us know if you'd like to have our office reach out to you to set up an initial consultation. Those are scheduled for about 2 hours and they are complimentary. So you don't have to worry about coming in and meeting with us and there suddenly being a bill that you have to pay. We want you to be able to come in and ask us the questions that you have so that we can best sit down and give you that information. We can usually let you know by the end of that meeting what our suggestions for planning would cost if you were to move ahead. And then just as always, we do have some more webinars coming up in the following weeks. So next week, we're actually going to be talking about understanding how Medicaid spend down works. Then the following weeks, we'll be talking about protecting loved ones from themselves. So when responsibility might be a concern from somebody, or substance abuse or addiction issues might be an issue, how you can protect people from themselves. And then the following week after that, we'll be actually in person at the Neville Public Museum in Green Bay doing our Wills versus Trust public seminar. So for any of those, if you want to sign up for them, please do so at estateplannинglive.com. So to get started, I guess, what's, some of the most common things we hear, I think, when people come in, whether it's the kids coming in as powers of attorney or as caregivers, or maybe the parents asking the questions with looking ahead towards the future of what care might look like if they were to receive it at home. And probably one of the most common questions we get is, what if I decide to pay a loved one for that care? And there are some potential pitfalls with that. The biggest being that you need to have it done in a very specific way if you're actually intending to pay that child. It's not like you can just say it's a payment or say it's compensation without any other sort of agreements in place and have that be okay.
Yeah, and it's really important too. There's often, income tax complications when it comes to actually paying someone, so it's good to be aware of. But one of the biggest things is just understanding that, is exactly as Justin said, you have an understanding that you're paying this child for, providing care, or maybe, picking up your groceries, whatever it would be. But if someone has long-term care concerns, where they think that Medicaid might be an option, and there are ways to receive Medicaid at home to kind of continue your goal of being at home. If you're trying to access Medicaid, then it's really important to understand, and we get this question a lot too, is, well, it shouldn't matter because I thought I could just gift a certain amount of money to my child every year. And right now that's that $17,000, annual gift tax exemption. We're really focusing on the IRS. Now, the IRS is a different government agency than the agency that actually handles Medicaid applications. And, government agencies are going to play by their own different sets of rules. So sometimes people think that there's a safe harbor for gifting. And really, when we're worried about long-term care or things like Medicaid, it's important to know that that amount's actually zero. So there's really no safe harbor for money that you can be gifting to a child or to anyone. And unfortunately, when you're doing especially cash payments or really any payments between a family member, there's a pretty strong assumption that that's going to be a gift, unless you have something that makes it really clear before you ever, transfer that money, that wasn't your intent, that it was for a service that someone is providing. So again, no real safe harbor for the gift, and you want to outline that intent clearly, especially if you're at all concerned about Medicaid, and care needs can always change. Even if your intent is not to go into a facility, it's important to keep it in mind if you're accessing care services, probably within the next 3 to 5 years.
Yeah, and so it's often a point of confusion of, well, why is it that we don't have the safe harbor for gifting? And while it's true that there are some exceptions to gifting not being counted as a divestment to a child, the assumption by Medicaid is always that anything you gifted or anything that you can't show records of, or there's not a fair market value exchange for services, right? They assume it's a gift and that it is a divestment and that it doesn't fall under one of the exceptions. So there are exceptions for, like, if you have an established pattern of giving, and it still has to be a reasonable amount. Like, I couldn't be gifting Abigail $17,000 every year, then need to apply to Medicaid and somehow have them not question that as, you know, being unreasonable. So, you know, we often have clients ask, well, what about like birthday gifts or Christmas gifts that were given to the kids? You know, if it's reasonable and you've been doing it and there's no break in that pattern, it's been happening for every year, then it's something you can make the argument that it's not a divestment. It wasn't for the intent of hiding it from care or from you know, avoiding having to spend it on your care. The problem is that is an argument you have to make. So it is certainly a risk in making gifts like that. Now, when it comes to paying a loved one for care, a lot of people ask, well, why can't I just gift it to that person? And the reason there is, you know, that's not necessarily an established pattern of giving. That's generally in amounts that are much higher than would be considered otherwise reasonable for a gift. I mean, if you look at the cost of care for at-home care for like a professional organization coming in, you might see $30 to $32 an hour as an average. That's not what most people would probably be paying their kids, but if they're getting anywhere near that, the numbers add up very quickly with how much money is being transferred. And then the biggest risk with that is there are specific rules through Wisconsin's Medicaid program that say in order for these payments to a child who's a caregiver to be okay and not be a divestment, there has to be a notarized caregiver agreement in place. So there's specific rules on what needs to be in place in order for these transfers to not be considered a divestment. So when we're talking about potential tax issues and Medicaid issues, what we're really referring to there is the tax issues are really on the child side of things. So unfortunately, fortunately or unfortunately, I guess it depends on how you feel about taxes. Most people don't tend to like taxes. Those payments to that child are compensation. So that means they are taxable income. So that child should be reporting those taxes on their tax return every year. Otherwise, they are committing tax fraud. And so it is almost never worth committing tax fraud. It is never worth committing tax fraud, let me put it that way, just to avoid paying taxes on things, just to have these payments under the table. You're creating more of a risk than it's worth. So the child themselves does need to pay taxes on that income. So that's their side of things. But on mom and dad's side of thing, or the family member who is making those payments, they need this caregiver agreement in place to show to Medicaid that these transfers were for payment for care that they received. And there are requirements of how those agreements have to be set up. We're not saying you can just create an agreement that says, you hand wrote it in and said, this is why I'm paying, my son or my daughter for care. This is what they were doing for me. There are specific requirements in it. It specifically has to be notarized. So you need to have it done effectively and actually correctly for these payments to not be considered a divestment. Now, once that's in place, it's perfectly fine to make those payments. They do have to be reasonable. Again, you certainly can't be exceeding what a professional organization should could come in and receive for that care that they're giving. You probably don't even want to be quite close to it, and generally we're about $10 an hour under that even on average. So you do have to be careful about how much you're transferring still, but it is very important to know that in order for those payments to be an option, for them not to be a divestment for somebody, you need to have a notarized caregiver agreement in place.
It can also be really helpful with family members in order to set the expectations for what a child or family member is supposed to be doing, the time that they're committing, what services they are comfortable or not comfortable providing. Not one caregiver can't necessarily do everything that someone might need. And it's important to talk through these conversations. That way you have a good plan in place. You understand who's providing what care, what those expectations are. And, you have a start date or end date to that if you're just trying to kind of temporarily get things in place. It can also be really helpful too to not just think of who your one person might be, but what if something happens to that person? It's a larger discussion for your family, outlining your expectations, your needs, so that way they're aware it can help serve you. I mean, it helps everyone to get on the same page, and your caregiver agreement can specifically define the services that you're providing, the rates that you're doing, the start and end, and really help to clarify expectations to allow you to create a plan that's really going to work to meet your needs.
And one thing that's very important to remember with these agreements is that they cannot be applied retroactively. So they must be in place before those payments are going out in order for this to not be a divestment. You can't try to fix the problem after the fact by creating this and saying, oh, this actually applies back to all those payments we made, 15 years ago, right? Or yeah, that's an exaggeration, but you can't retroactively apply them. And I would say that's relatively common that we have people come in and say, oh, mom or dad was paying me to help them out. Is that okay? And we find out that there never was a caregiver agreement in place. And unfortunately, in that situation, we have to say, well, you really can't retroactively apply this. It's an issue that we know about now, and it's better to know about it and know how to deal with it than to not be told that. But there's maybe not a way to fix it unless that child was able to actually fully cure that divestment and give all of the money back that they'd received over, at least the last 5 years for that to cure that divestment. Now, that's often very difficult to do because if the child thought, well, I was receiving this as payment, I should be able to use it however I want, it might not be there to give back anymore. So it does have to be in place prospectively. It can't be retroactively applied. If you are always able to set these agreements up yourself as the person who's paying for care, but it's also really important to know that if you would need this type of care later on, if you would want to be able to pay a loved one for that care that they're providing, but maybe you don't have capacity to sign one of those agreements at that time, you need to make sure that your financial power of attorney document that you have includes the authority for your agent to be able to create this agreement on your behalf.
And it's important too, and we often talk about veterans benefits, and it's a really common question that we get related to how to pay for care. All of our attorneys at Hooper Law Office are VA accredited, so you get this question probably more than most estate planning attorneys. But what's important to understand is there are options, and we talk about them a lot as to wartime veterans and the surviving spouses of wartime veterans. Due to their wartime service, which are defined, periods of time. But if you are a wartime veteran, there's an aided attendance benefit, which is kind of the highest level of the improved pension program. And what this would allow you to do is actually, receive a tax-free benefit amount, and it's set based on, if you're a single veteran, if you're the surviving spouse of a veteran, if you're two veterans together, the amounts kind of incrementally go up. So not getting into too much detail on that benefit because we'll have a whole other webinar on that. But what can be really important for veterans to know is that it's an excellent benefit to allow you to still maintain care at home, but it relates directly to having that caregiver agreement in place, because what the VA does is it helps to provide a certain amount of max benefit. So say you're that single veteran, I think it's about $2,400,
$2,600 a month. Yeah.
So what they do is they compare that to your income, and there's other asset requirements, but they pay up to that value related to your income. So if you had, over that benefit amount, they wouldn't pay you anything. If you had a difference between the amount, your income, and that max benefit, they pay you the difference. What is excellent about this program as it relates to long-term care is they reduce from your countable income what your unreimbursed medical expenses, and paying a child if you have a caregiver agreement can be one of those expenses. So it can actually allow you to, get money to help pay for care at home and pay a family member for that care. But it's really important in order to, have that count, that you have this caregiver agreement in place. Otherwise, you have difficulty with proving that too, just like with Medicaid. But for veterans who, wartime veterans or the surviving spouse of a wartime veteran, the rest of those benefits aside, it can be really, really important to know that you could use that benefit to receive care at home that is provided by a family member.
Yeah. So, there are a lot of ways to get sources for these funds. It can be from your own assets, from your own income. It could be utilized in coordination with the VA's improved pension benefit for wartime veterans or their surviving spouses. There's a lot of ways to coordinate this, but it is very important to have the agreement in place first and foremost. There's a lot of things people try to do when paying loved ones for care, ways to reimburse them for the care they've provided, whether that's during lifetime or at death, that end up not being great planning. So a lot of times people will try to do ask about lump sum payments. Can I just give a lump sum payment? Is that okay? And it has to be based off of the care that's actually provided, and it has to be an amount that they would have not exceeded for care received during their life expectancy too. So you have to be very careful with lump sum payments because they can look like a gift. They can be counted as a divestment. So it's generally better to say, well, we're paying based off of the care actually provided. There are also times where people will say, well, okay, I won't pay them then. I won't pay them at all. But what I'll do is I will increase the portion of the estate that they actually receive from me, or I'll promise them a certain asset or a certain account, through payable on death or transfer on death to provide that reimbursement. That way it's not taxable income to them. It's not a divestment, right? And which both of those things are true. If you leave an asset to somebody through your estate, that's not necessarily a divestment. Medicaid may be able to come back and take it, recover it from your estate, but it's not a divestment. The biggest issue with doing that or trying to rely on that, I sort of gave my answer away there a little bit, but Medicaid, if that person does receive Medicaid assistance, first of all, that individual is going to have to spend through some of their assets in order to qualify for Medicaid first. They have to be below a certain point. And I won't go into a whole lot of detail on what those numbers are because it's a long discussion and it varies a lot between whether you're married or single. But let's just use a single individual as an example. A single individual can only have about $2,000 in countable assets when they're on Medicaid. So in order to be receiving Medicaid assistance, you already have to be pretty low in terms of the assets that person has. Well, if you promised an increased portion of the estate to pay for that, reimburse that individual for the care they've provided, that might be a larger portion of the estate that they're receiving, but a larger portion of what? In theory, they might have very little left, or they might have nothing left, because Medicaid also has a program called estate recovery in Wisconsin, which can recover against probate assets. It can recover against, payable on death assets. It can recover against revocable trusts that were created after August 1st of 2014. So Wisconsin has a very expanded ability for Medicaid as a creditor to come in against a lot of different sources of funds and take it as reimbursement. So again, you can promise all of these things to these caregivers to compensate them, to increase their share of the estate in ways that won't be counted as a gift during lifetime or a divestment for Medicaid, and won't necessarily increase the tax liability of the kid. The problem with that, though, is you just don't know what exactly is going to remain at the time of that estate administration. So it's better to find a way, if your desire truly is to compensate your child, it's better to find a way to do that legally without creating a divestment for care while they're providing that care than it is to, at some point in the future, promise them something. So you can run into a lot of issues, not just with Medicaid, with taxes, but also just with your intended result actually coming to fruition. If you don't look at all of the issues that can be created by both gifting during lifetime, by not having these agreements in place, but also just not making sure assets survive that process because of having to spend down, you run the risk of that person never receiving compensation too. So we're not saying you should always pay your loved one for care. We're not saying that you have to do that as an option. This is more if you, as the person who is receiving care, would like to pay that person for care, then you have a way to do that. And there are times where that makes perfect sense. Like if a child is taking time off of work, they are losing their other income source, or it's disrupting their ability to work, and they need to continue living their own lives and paying their own expenses. It's perfectly fine to pay them for that level of care that they're providing. Again, if that's what you would like to do, and you want to do it in a way that you're not causing a problem for Medicaid, you need to have the caregiver agreement in place.
And talking just for a little bit on the more kind of simple everyday side of Medicaid too, I think that where Justin's talking about reimbursement when you've passed away, I get clients that also say, well, I'm not paying someone to come in and provide care, but you know, my son or my daughter, they do pick up groceries for me, and they just tell me, this is what I bought for you, and I write them a check. And the difficulty sometimes with little reimbursements as well is in the fact that they might appear to be gifts, especially if you're just paying cash or checks or something that don't show up clearly on your statements. Because sometimes if you're reimbursing a child for everyday expenses, either one thing, you have to hold on to the receipts, which is kind of, more like a administrative difficulty to hold on to those receipts. So what can be better in that situation would be having your child be a financial power of attorney, so that way they could actually sign a check for you when they're at the grocery store. That could be a really excellent option if you have a debit card or credit card, because what happens in terms of the record keeping side of those smaller reimbursements is that they're going to appear directly on your statements, Pick and Save or Meyer grocery store. Again, just to pick on grocery stores, but that could be any number of reimbursements, gas for driving you around, helping to, if they actually paid when you were at the doctor's appointment, things like that. Little reimbursements are also important to keep track of, so that way they're not looked at as a gift. And when I tell my clients to hold on to receipts, I think that feels the most stressful. So maybe the other option then too is, again, having a good power of attorney, so that way they can actually pay those checks or write those checks. Now pay your bills directly rather than reimbursing them and having to keep a paper trail. Or, debit cards do it for you, or credit cards, because they're going to show up at the point of the purchase. So, a little related to caregiving, but sometimes that's just the simple things that people are doing. And you might want to be aware of that too. So that way you don't have to actually go back and pull 5 years of, receipts or payments when you were just reimbursing a child rather than, them necessarily providing direct care.
Yeah. And I mean, you can show, like Abigail said, reimbursements, keeping the receipts, all of those sorts of things. And the reason this often needs to happen is because the caregiver themselves, caregiving child, went to the grocery store, bought mom and dad's groceries for them, brought it back, and then needed reimbursement for it. They weren't necessarily expected to make a gift on that behalf. Maybe they didn't expect reimbursement either. But if the parent is trying to be the one to pay for that, whether it's through reimbursement or not, whether it's directly, it is much easier to show Medicaid. They don't question those payments coming from accounts if it was directly to the grocery store. What they will question and will look at, and you'll have to prove that it wasn't a gift, is if it's cash amounts coming out or checks to individuals coming out. They're going to ask, why was this routinely coming out of the account like this? What was going on? Why was $100 a week being taken out of your account in cash?
And they have questioned that, and unfortunately a case out of Milwaukee, a woman was taking regular cash withdrawals because she preferred to live her life, with cash. And they requested, basically 5 years worth of receipts, which is very difficult to produce. So.
I can tell you, I don't hold on to
that
level of receipts, but
so.
And so this can often be difficult, this transition to using a card, or, a transition to paying for these things in a different way than your loved ones might be used to. I know, especially with older generations, it's more likely that they were paying with cash or check. I mean, it was more likely that they were paying through alternative means as opposed to through cards, where it's just a, electronic transaction at that point. So it can be a difficult switch, which is where if the child who is, maybe if it's the child or any other person who is acting as their power of attorney agent for finances, if they are able to go to the store using that person's checkbook or that person's debit card as the power of attorney agent, tied to their account, that's a much easier thing to keep track of. In fact, you hardly have to keep track of it. The bank is doing that for you. But it is not something you want to necessarily have routine reimbursements for. Again, not because you couldn't try to prove that it wasn't a gift, that it was just a reimbursement. But that's, again, something at the time of Medicaid application that you have to put additional effort into showing proof that it wasn't a gift. It's much easier to have a very easy paper trail, so to speak, a digital paper trail to follow, showing exactly where things went to, fair market value exchange for groceries, right, to the grocery store, than it is to try to keep track of all of these receipts, show that all of these payments were in divestments. You run the risk of having a penalty then from Medicaid saying, well, we won't provide payment for your care for a certain number of months because these gifts occurred and they were never cured, they were never given back in full. So you just have to be very careful with reimbursements, making sure that you're doing it the right way with the right documentation. And ideally, if you have the ability to do this, use debit cards, use the cards for that person's account as a power of attorney. I'm not saying just take their debit card and start using things. You still have to have the right authorities to act on their behalf financially, but it's much better to do that than it is to use your own funds and seek reimbursement, because that's where the issues can really come up. And there are arguments you can make, like we've said, but it is much, much easier and safer for the person who might be receiving care in a facility at some point to not have to make the argument. Because Medicaid, unlike the criminal justice system where you're innocent until proven guilty, Medicaid's sort of the opposite, where you are, they assume that things were gifts, they assume things were divestments, and you have to prove the opposite. So it works the opposite of the criminal justice system in that sense. So you're better off not having to prove that you're innocent. Let's put it that way.
Mm-hmm. I don't think we've seen any questions come through, but again, there's the Q&A feature for those who are attending live. So give that a minute in case anyone had any questions about what we talked about today.
Yeah, and so I'll kind of wrap up here. If any questions come in, we'll answer them. But just again, a reminder to keep an eye out for the feedback form and the materials we'll send out to your email. If you would like us to reach out to you, please fill out that feedback form and let us mark that you would like us to contact you for an initial consultation. Again, those are scheduled for about 2 hours and they are complimentary. So you come in and talk to us and we can let you know what the cost would be for any planning we suggest by the end of that meeting, generally speaking. But we do ask for a lot of information when you come to those meetings, a lot of financial information on the family or the people who might be involved, because it really helps us get a sense of what it is we actually are working with and need to do for that individual. If we don't have that information, it can be really hard to give advice without knowing the specifics. I know we get a lot of questions just in general from people who say, well, here's my situation.
It's real simple.
It's really simple. What do I need to do? And it's too hard to give a definitive answer without looking at all of the specifics. And, little things can make a big difference sometimes. Then one other thing, our topics upcoming for the upcoming weeks here. Next week, we're going to be talking on understanding Medicaid spend down and what that actually means and what it can look like for loved ones, protecting loved ones from themselves, potentially, if there's concerns about responsibility. And by protection, we mean protecting their inheritance or what you're leaving them from that individual. And then the week after that, we'll actually be in person at the Green Bay, the Neville Public Museum in Green Bay for our Wills versus Trust Public Seminar. And again, you can sign up for all of those on estateplannинglive.com. Please feel free to do so. We love to see you all and especially love to see you all in person. Again, I'm not seeing any questions. So with that, we will sign off and let you go enjoy the rest of your days. We hope to see you guys in the upcoming weeks.